Well, hello everyone. Today we have a very interesting skew to our normal technical slash CISO type topics. I'd very much like to introduce you to Andrew Priest. Andrew is a partner in the commercial and technology arm of Birketts. Birketts is a firm that we've worked with for many years and got to know and respect greatly. And this whole topic and conversation has come out of a lot of kind of debates that we've had about doing the right thing around the very, very complicated areas of data protection, regulation, compliance, privacy, transfer, residence, processing, controlling, destruction, all the laws and so on and so forth. It's an incredibly complicated area. And it's something that we see and have great concern with doing it right, not only as a commercial firm, and obviously from a Birketts view, from a legal advisory perspective, but implementing that on a global scale and even within different states. And it's very interesting that so many cyber security firms, we are concerned that they don't necessarily give due consideration to this in our remote working, totally connected global world, where we as providers of consultancy sit in our instance, 7 different geographic locations, and then our clients can be in sometimes 20 plus. It's quite an extraordinary lattice. But Andrew, let's just jump straight in. We got talking about data protection, compliance, and privacy, and this kicked off. And tell me, just from a high level, what are some of the things that are concerning you as this evolves, and where are the gaps and where do we need to be more mindful as we all operate within this lattice of regulation?
Well, I think you probably touched on it in just what you said there, really, because I think for a long time, data protection laws have been very much specific to countries or regions. So in the UK, for example, we've had data protection laws since 1998. The EU goes back a little bit before that, but we're kind of quite well established, if you like, in the UK. So where we're talking about, data being processed, data being transferred within the UK and the EU, I think it's all sort of fairly well established as to what should be happening. I think when you start to look at the world as a whole, things do become a lot more complicated. And the world now of data in particular, it is global. Businesses are global businesses these days, many of them, and they're targeting customers all around the world. From an individual's point of view, social interactions are taking place all around the world. Goods and services are being bought from various companies all around the world. So data and data protection is very much a global phenomenon, if you like, these days. And I think we're waiting for the sort of the legislation in various countries to catch up. And increasingly we are looking at things on more of a global basis, and that's where the complications really start to rise, because different countries do have different sets of rules and regulations. Some are much more robust than others. Some have very limited data protection. Others have sort of moderate levels, and it's quite a minefield, really, to establish which laws you have to comply with. And unfortunately, there's no easy answers to these things.
There isn't there? A model we discussed in quite great depth was interesting, wasn't there? That we can set sort of 3 bars, if you like, of tests. One is baseline regulation, the law, and the legislation that goes with it. Secondly, our commercial agreements with our clients and how we all work together. And then I guess, what we call better, which is raising your own bar to make sure that we, encompass things from the spirit of what all this is trying to embody. But tell me some of your thoughts around this, because it's been quite an interesting activity, isn't it? Throwing all this around and trying to, make sure that we are all in the spirit of doing things correctly as well as the law.
Yeah, well, I mean, we usually sort of take the view that, there are certain sort of fundamental principles that apply to data protection, and certainly in the UK and the EU, our legislation is based on sort of several principles about how you protect data, that you treat it lawfully, that you treat it fairly, that you're transparent, that you don't use it except for specified purposes, that you only retain it for so long. Those sorts of basic core principles, if you like. And I think what we try and do is, we, irrespective of sort of when we're dealing with other countries, irrespective of whether they've got legislation in place or not, we try to make sure that those principles are complied with, so that we're almost looking to moving towards some sort of standard, if you like, of data protection, data privacy based on those principles, if you like. And that's where we see the challenges, because not everyone has those principles in place in their jurisdiction. So not everyone is sort of willing to sort of step up to that, if you like.
Do you think that there's a lot of confusion as well? Do you think that's one of the drivers of confusion, Andrew, in this sense?
If you have the experience, then the confusion shouldn't be there. I think it's when you come across people sort of having to grapple with these issues, if you like, for the first time. And I think it's then quite difficult to explain to them, the reasons why you should be treating the data this way. And they say, well, we're not obliged to do what you're asking us to do. And you say, well, yes, you might not be, but we have to think of it from an individual's point of view, making sure that the data is protected, and there are reasons why the data has to be protected, because if it's not protected, then you've got cybersecurity threats. People can come in, they can take the data, and basically make people's lives very difficult. So we have to sometimes go back to the underlying reasons about why we have data protection rules in the first place, and it is about protecting people's privacy.
That's the spirit, isn't it, that we're after, and it goes back to that model of law, commercial agreement, and better in terms of bars. But a really interesting thing that we've been observing, and again, we were throwing this around as a brainstorm with yourself and some other partners as well, was we see a real different set from our clients' perspective. So when working with counsel in one of our clients, usually a major corporation, US, UK, wherever it might be, counsel are very, very specific on the parameters. But then after those T's and C's and agreements and such are in place, we then see the audit come out. And that's from the organization itself saying, okay, we need to audit, you as a provider. And it's fascinating. And it's a common theme that we receive the DPA audit, which is a great thing. And providers should be able to answer those truthfully and have the controls in place to protect. But the big thing that we see so consistently is a DPA question set of treating us as if we have got all the data in the first instance, when from a cybersecurity perspective, we are testing a client and running scenarios to make sure that we can't get to the data. So it's almost like the framework is a template and designed to fit general data processors and controllers. So it always is, it makes us chuckle a little bit sometimes. It says further down in the audit, do you do pen testing? And it's sort of, there's the reveal, isn't it, that this DPA is not actually designed for the purpose of cybersecurity testing. Where do you think it's going wrong there? What's happening in providers there? Are they taking things a bit too templatey and a bit too generically and failing to reach the point?
Yeah, you're probably right. I mean, there is a risk of sort of things, the underlying issues sometimes not being addressed, because as lawyers, it's very easy to sort of put in place documentation, so we can say, here's a data protection addendum, you're a processor, we expect you to sign this, and it's almost sort of becomes sort of standardized wording, if you like, and people sign it, and that's it, and then move on without actually sort of thinking about, well, actually, what does this actually mean in practical terms as to what I should be having in place? What should we be doing? What sort of security protection should we be having? And you really need someone within the organization that is going to sort of look at that from a practical perspective, as opposed to, you know, someone that's you know, just trying to get the contract signed. So I think that's sometimes where we see a bit of a divergence, is you can write on paper to say you've got to have these sort of operational and physical security measures in place, but actually it's a practical thing. Those do actually have to be in place.
I totally agree. And then out of that sort of, you know, I guess, vulnerability to the process, we all agreed that, you know, perhaps we should take a different type of view, which is when one does cybersecurity, even though you don't have that client data, technically, if we were able to compromise a client site, which is the objective of the exercise, do we have that client data? And one line is enough. You know, normally we work with test accounts and dummy data, but, you know, invariably there's always a live site. So processing or a data processor isn't enough. This is where the concept data controller comes in place, and, you know, raising the game. And it's okay to be raising the game to that, even though we're not technically a data controller. Tell me some of your thoughts about that, and, you know, how one, you know, can raise their game and go to a high level standard, because everyone's fearful of becoming a data controller, aren't they? And why are they concerned? Because there's legitimate purpose.
Yeah, I mean, I think there's one thing is as you say, raising the standards of data protection, and another thing altogether different is actually sort of admitting or saying that you're a data controller, because certainly under the UK legislation, the EU legislation, if you're a data controller, you're taking on the majority of the obligations under the data protection rules, and it's you essentially that's then in the firing line for you know, any non-compliance, and then you're into the, well, you know, and we know the fines can be significant for serious breaches and so on. So, you know, I think there's a reluctance to take on that role of data controller if you're not within that definition of that term. So if you're not the entity, if you like, that determines the purposes for the data, or how the data is processed, then you know, stay as a processor. But that, as I say, that doesn't mean to say that you know, you can't work together with your data controller, because a data processor is just someone who processes data on behalf of the controller. So, you know, please work with the controller to establish what should and shouldn't be in place to protect the data. But I don't think you necessarily need to sort of step up and admit to being a controller.
No, I absolutely agree. But it's the again, back to the spirit of things, isn't it? You know, do you have adequate protections and, you know, safeguards in place? It then led to a very interesting conversation with one of our clients. This is a client based in the central time of the US. And this client suffers from a very interesting concept. They've identified it themselves: data transfer and what constitutes a data transfer. So we've got this concept of cloud, obviously, and then, you know, cloud is physical. Obviously, somewhere it's got to be sitting physically, and then it's obviously presented in a virtual way in different jurisdictions than we can choose. And we were discussing this, and they were having problems in the US between state to state. And their point was, but we hold the data, let's say in Chicago, in a random example here, but in the same sort of region. But they might have, you know, an East Coast subsidiary or an East Coast set of employees. And it was very interesting because they suffer that transfer. And it wasn't originally what I thought. It was a little bit, not contrived, but it was a bit more technical. The idea being that the person in the East Coast can access that data. And are they physically transferring it as a file? No, it's in the representation of keyboard and screen clicks and visual representation of screen. Technically, it's a transfer from a a legal perspective, well, not, sorry, from a technical perspective, and from forensics, if it's in a browser, there's ways of reconstructing that data. So tell me your thoughts on this, because we're really splitting hairs now, aren't we?
Well, we do get this issue rises quite a lot, actually, and I think, again, coming back to the UK and the EU, it's the legislation doesn't define what it means by a transfer. It talks about a transfer of data, but it's been now well established that that can either be a physical transfer of data, like you're transferring files, like you mentioned, or it can actually be someone in another country just having, being allowed to have access to that data. And we see it quite a lot in terms of sort of IT support companies, for example, that might be based in, say, India, for example, who actually have remote access to the data as part of their support obligations.
Yes.
And they will see people's personal data. There won't be any personal data moving from one server in India, in the UK to India or anything like that. But the fact that it's accessible in India means that that is a data transfer. And then you're into the application of the data transfer rules, which, again, pretty complicated, but they're there, they can be followed through, and mechanisms can be put in place to make sure that the data is safeguarded. And I'm not surprised that you mention it in terms of the US, because I'm not a US data protection lawyer, but I know that over in the US, data protection is very much done on a sort of a state-by-state basis at the moment. There is no overriding sort of federal legislation. So it's not dissimilar to the situation that we might have out here, where you say you're transferring data outside of the EU to another country. So similar considerations. But yes, I think from a layman's point of view, if you like, if you say, well, is that a transfer of data? They probably say no, but from a legal point of view, it very much is.
And that is absolutely fascinating. So then it brings down to the next layer, which is data residency. That original, in your scenario, Andrew, US data is resident in a state in, let's say in AWS, for example, in Chicago or wherever. Fascinating. Is it now resident in India? Because there has been a form of transfer of that data through a keyboard, mouse, clicks, and screen transfer. Caching in the browser. Is it resident there? Interesting. Your thoughts?
Probably not, because it depends. I think it depends whether probably depends on whether it's saved there. If they're downloading files, then yes, it probably would be resident in that other country. If they're just accessing it for the purposes of dealing in emails and that sort of thing, then probably no. But again, it very much depends on the individual circumstances and the technicalities involved, I think.
It's a real complicated one, isn't it? As service providers themselves, are remote working and in different jurisdictions. Some scenarios we experience, we're in 7 countries, as mentioned, and some of our clients might be in 20 or 40 countries, even more. What a mesh of data. And from a legal and a lawyer's perspective, as a technology partner, where do you even begin to advise and unpick that scenario? Because it's super complex, isn't it? And keep pulling at that piece of string and becomes a rope.
Yeah, it certainly can be super complex. I mean, I think the starting point, we always say to clients, well, look, talk us through your data flows for this particular project. And sometimes they can't do that, or sometimes it takes them a while so they say, well, we'll have to go away and actually work out, how the data is flowing. And I think that's always our starting point. We don't really like to advise clients without knowing what data is flowing to where, from whom to whom, and so on. And I think once we start to build that picture up, then you can put in place some of the protections that are then necessary.
Do you find, though, Andrew, that people actually know where their data flows?
Well, no, in some cases they don't, and in some cases, projects start, and you think, well, it's just going to be quite a simple data flowing from this country to this country, but actually, as the project progresses, you talk to them 6 months later, and they say, well, actually, we found out that we're sending data to this country, or it expands as the project expands, and keeping up to date with that from a data protection point of view can be quite challenging as well, because you're almost always sort of trying to play catch up.
It's really interesting. I'll muddy the waters one more step. So many organizations, let's say your scenario about an IT service provider, they will have supply chain. So now we're dealing with supply chain where people have shrunk their core activities and rely on third parties in relation to the provision of that facility, if you like, the ability and facility to do or perform their service. So how on earth do we now unpick a fourth dimension here, which is supply chain and the obligations therein, and map those, Andrew? Because
it's well, you're right, that's where it does become very complex, because technically you as the data controller, you're responsible for knowing where that data is at all times, and you would then need to ask questions about the supply chain and who has access to that data and at what points, and quite often these things don't come to light until there's a subject access request or something like that, and you have to you really have to sort of get to the bottom of these issues. But it is very complex, and it's quite difficult, as I say, to get people to focus on those at the point where you're sort of signing the initial contract. And sometimes people don't know, but sometimes people don't want to think about that too much. And it's our job as data protection lawyers to get them to, try and think about those sort of things, if you like.
Absolutely, it just goes to show the total elastic nature of data these days, isn't it, across service providers, jurisdictions, both in terms of the primary, let's say in this scenario, a client of ours, and providers of those services.
Yeah, that's why I think in a lot of cases you won't always get it right, because the more complicated the transactions, the harder it is to sort of be able to say 100% we've got compliance here. Because, as you say, data moves so quickly, and it's so easy to move data from one jurisdiction to another, and it's very difficult to hand on heart say, yes, we've got 100% compliance here. But I think a lot of the time we have to sort of just try and be sensible about things and make sure that we've at least asked the questions, tried to address the issues, and have taken a sensible approach.
That makes sense. So on that basis, then, let's say people do take that kind of thorough view and spirit of the law, because obviously the law is there as the basics, but certainly is from our perspective. There are obligations morally, ethically, commercially on top of that as well. What are the mistakes that you see, Andrew, people make in this area?
Mistakes. Well, I guess it's probably not putting in place the documentation, if you like. I think a lot of the mistakes come around transfers. It's sort of what we've been talking about, not recognizing that there is a transfer, or if they do recognize that there is a transfer, not taking that extra step and putting in place the transfer mechanisms, if you like, that the legislation requires. So I think that's quite often the mistakes that we see. They just haven't sort of followed that rabbit down the hole, if you like, and gone to the logical conclusion.
Close that off.
Yeah.
No, it's interesting. In some of our conversations, you also mentioned the UK Data Protection Day. Do you think that drives awareness a lot more now? I know it's been around, 18 cycles, something of that nature?
Yeah, something like that. Yes, I think this is the 18th Data Protection Day. Again, that's becoming, that started off as a European thing, and it's now adopted around the world. But it's essentially to raise awareness of data protection issues, data protection challenges, educating people about data protection. So I think it is important that we recognize that, and data protection is never going to be perfect, and there are always going to be challenges. And coming back to the globalization of businesses, we're looking at data protection legislation around the world. We still don't have data protection legislation in all countries around the world. I think the last numbers I looked at was something like 84-85% of countries around the world do have some sort of data protection legislation. But that does mean that there are some countries that have very little, and so I think we're Data Protection Day raising awareness, I think, is going to help to raise standards, help to raise awareness, and and as I say, it's becoming a we don't have a data protection global authority yet, but maybe in a few years' time, that I think maybe that's the way that we're moving. We're seeing sort of increased. I mean, each jurisdiction has its own regulatory authority. Obviously, in the UK, we've got the Information Commissioner's Office. There are supervisory authorities throughout the EU. Other countries have their equivalent regulators, and we're going to see increasing amounts of cooperation between the various regulators. And I think that will help to put in place rules and guidance that, if you are doing business around the world, it'll make it easier to comply because there will be certain standards set.
Makes sense. I mean, we saw in August, I think of last year, the Indian DPDP kick in, and that's been a wonderful thing from our perspective, and more maturity rolling out. But as a sort of final comment, from your practice's perspective, where do you see the next few years going, Andrew? What excites you about that, and what challenges do you foresee as you drive technology and commercial together around this whole subject?
Well, I think it is this globalization point, really. I think we're lucky that in the UK and the EU we do have pretty robust data protection laws, rules, practices, and we're looking, I think, to sort of roll that out, if you like, or we're starting to see that roll out as almost like a gold standard, if you like, for legislation around the world. I'm not saying that we expect lots of all these other countries to be adopting the same legislation, because it just doesn't happen that way. But I think it is looked at as a gold standard. So we're quite excited about that, because obviously that will help us with, if we understand what the legislation is and the practices are here in the UK and in the EU, that will help us with understanding the way that other countries are adopting similar processes and procedures around the world. I think also the US is interesting state by state regulation at the moment, and I think that within a fairly short space of time is going to move to a much more sort of coherent federal basis, and we'll see something equivalent to, say, the GDPR that we've got over here.
It's exciting, isn't it? It's I think if you kind of, this area gives you an intellectual challenge. It's such a rabbit warren of challenges and opportunities, and I find it personally absolutely fascinating, and working with you guys on it. So I think we'll leave it there at this point. But Andrew Priest, partner commercial and technology in Birketts law firm, thank you very much, and what an interesting conversation.
Yeah, thank you.